Hi, my name is Nick Morgan. I'm a partner at Paul Hastings in the Investigations and White Collar Defense Group. My one big thing for this year's Securities Enforcement Forum West is 2020 hindsight. The actions we take now, whether they're changes to valuations or methodologies or policies and procedures, will be scrutinized by regulators for the months and years to come. So as you work your way out of this coronavirus market, keep in mind 2020 hindsight. Thank you.
Hi, this is Jordan Eth from MoFo, and here's my one big thing for Securities Enforcement West 2020. It's how much I miss 44 Montgomery Street. Having the security guard go through my backpack, waiting to see if my name is really on the list, and then walking into that testimony room and realizing I forgot to bring my own water. Hope to be back there and see you all real soon.
Welcome back. So we started this conference in 2014, which is one panel, which was a director's panel. It was made up of only of the current and former West Coast regional directors. The personalities and the insights and the historical perspectives that came out of that panel made it so popular that one panel quickly turned into a full day of panels anchored around the director's panel. So this is a special group of attorneys that work great together on a panel, even if the former directors are sometimes inclined to gang up on the current SEC directors. But our moderator for today's panel is Jordan Eth. Jordan's a partner and co-chair of Morrison and Foerster's Global Securities Litigation Enforcement and White Collar Defense Group. Jordan's truly one of the leading securities litigators in the United States, and he's a fixture in the Bay Area with more than 3 decades of experience representing public companies and their officers and directors in about every type of matter that you can imagine. In fact, I first came across Jordan years ago when he had the rare accomplishment of litigating and winning a securities class action jury trial against his client JDS Uniphase that had been seeking $20 billion in damages. Jordan, it's always great to have you. Welcome.
Nice to see you, Bruce.
Now let me introduce Jina Choi, who has been a star at this conference since day one. She was originally here in her capacity as director of the SEC's San Francisco regional office, where she was on the staff for over 16 years. But today she's a partner at Morrison and Foerster in San Francisco, where she represents public and pre-IPO companies, financial institutions, asset management firms, boards of directors, and more. Jina is known in and out of the SEC for her leadership while she was at the agency and simply for being one of the best in the business in private practice. Welcome, Jina.
Oh, thanks, Bruce.
Now I'm pleased to introduce Michele Layne, who has also been with us every year since 2014, as she is the regional director for the SEC's Los Angeles office, and she has served at the SEC since 2005 and led the LA office since 2012. Under Michele's leadership, the LA office has produced some of the agency's most significant cases, including the enforcement action against Countrywide CEO Angelo Mozillo that resulted in the largest SEC penalty ever paid by a public company's senior executive, and the SEC's first ever Sarbanes-Oxley Act clawback case. It's always a highlight for me to work with Michele in this conference. Michele, welcome, and thank you again for joining us.
Thank you, and thank you for shaving 20 years off my age by starting in 2005.
Well, you're welcome, I guess. Randall Lee is a partner at Cooley with nearly 30 years of experience in both government and the private sector. Randall is the former regional director for the Pacific region of the SEC, where he was the SEC's top official in 9 Western states, including California. Randall's also the first Asian American ever to head an SEC regional office, leading a staff of approximately 175 attorneys, accountants, compliance examiners, and support personnel. And of course, Randall was also previously an AUSA at the U.S. Attorney's Office in Los Angeles, as well as deputy chief of the major fraud section. Welcome, Randall.
Thank you, Bruce. It's great to be here again.
Finally, delighted to be joined by Erin Schneider, who was named director of the SEC's San Francisco regional office almost exactly 1 year ago, succeeding Jina Choi. Erin joined the SEC in 2005 and steadily rose through the ranks. Also was part of the asset management unit in the enforcement division. And many of Erin's cases are well known in the Bay Area and around the world, including matters involving Elon Musk's tweets and the fraud involving Theranos and its founder and CEO, Elizabeth Holmes. It's been great working with Erin on this West Coast event. Erin, welcome back.
Thanks so much, Bruce.
Well, thank you all. And Jordan, I'm pleased to turn it over to you.
Thanks, Bruce, and good afternoon, everybody, from my older boys' room in Marin County. We're going to start the way every conversation has started for the last 2 months, which is, how are you doing? And we're going to start with Michele. 1 to 2 sentences. Michele, how's it going?
It's going as well as could be expected. We're happy to have our 2 college-age sons home, even though that means endless cleaning, cooking, and laundry. But, on the work front, we're just really pleased that the SEC has been able to miraculously keep going through our technology and our being somewhat, accustomed to working from home. So, and trying to keep everyone's morale up, which has been, I think, fairly successful. And we're just very grateful to have the jobs that we do.
Well, thank you, Michele. And maybe you can tell me later how you got your college-age boys to do the laundry, cooking, and cleaning.
No. They're not doing it.
Okay, well, I'll tell you how to get them to do it. All right, Erin, how are you doing?
So I'm also doing fine. I think, I've also home with my kids, and so kind of shocked at the number of times they need to eat every day and the number of classes that they use. But, I think the office is doing well, just like Michele mentioned for Los Angeles. It's been a real challenge, as I'm sure it has been for all of your organizations, trying to, keep an office together and cohesive. But I think the agency has done a really good job of making people, feel safe and appreciated. So I've been just really surprised at how well everyone's adapted.
All right. And Randall, how's it going for you?
I'm great. I'm good. In a weird way, that the quarantine has been good for my self-esteem, because I'm learning all kinds of new things, whether I learned to bake bread for the first time or give myself a haircut. I have this weird sense of accomplishment. So it's good.
That's excellent. Send me some bread. I'll take care of the haircut myself. And Jina, on to you. How's it going for you?
It's okay. I have 2 teenagers here, and so it is like an all-day and all-night diner, and also like a homeschool. So we're fighting for internet today, so I'm hoping that everything goes smoothly. I have one kid who is taking an AP test, but I think we're going to do okay.
All right, as long as you've got it for the next hour or so. Okay, so let's dive into some of the topics. Michele, we talked a little bit about how it's going for the SEC during this crisis. Maybe you can be a little more specific, and in particular, document gathering, testimony, how are you meeting internally? How are you doing Wells meetings? All of that. How's the LA office getting along with all of these restrictions?
Sure. So first, I should have said this before in answer to your how are you doing question. So giving the SEC admonition here from home, the views I expressed today are those of my own and do not necessarily reflect those of the commission or other members of the staff. So those are all really good questions, Jordan. And I'm, actually really happy to say that, for most things, we have been able to pretty much carry on somewhat as business as usual. So first, with respect to documents, the gathering, the review, obviously, in this age of electronic document discovery, we send out our subpoenas, the productions come in, they're still processed, and the teams are reviewing them in Recamind. So I've not heard of any issues with that. Certainly, there have been situations where parties are having some challenges, producing things just because of, the constraints on their organizations. And we're obviously sympathetic to that and have been working with folks, I think, very well in trying to, get the documents we need, mindful and receptive to, challenges on the other end. With respect to testimony, as I think, you guys all know from being on the other side, as well as depositions, it's less than ideal doing them remotely, but we have been able to conduct testimonies in instances where the defense has agreed to do so. So, of course, it is somewhat challenging, and we're trying to be, very judicious in which cases we're proceeding with testimony. And of course, like anything, it's always facts and circumstances, what the need is to do it, right now, based on the type of case, if there's any exigencies involved. And now, though, that it seems when initially we all went on mandatory telework, no one knew how long it was going to last. But now, given that, this may be our situation for some time, I think the staff is getting more comfortable, and I think defense counsel too, and proceeding to try wherever possible to take testimony. So that's been working out, I think, reasonably well. As far as internal meetings, just like for all you guys, WebEx, I don't know, or Zoom, not that it's our new best friend, but it's our new best friend. So we're proceeding with that, notwithstanding buffering and technical challenges, and everybody's doing the best they can given the situation. We've had Wells meetings where it's a little bit like this with different parties, counsel, the front office, the LA team, and again, no, not as ideal as in person, but it's the next best thing, and that's been working. And then litigation, that really is depending upon the judge for the most part. So we've had cases where the other side's requested a continuance. We've requested a couple in some instances. Some have been granted, some have been granted with modification, some have not. So we have several matters that, I would say are still actively litigating. The only change being the hearings are being held telephonically. So things are, by all measures, I think proceeding as, well as could be expected, despite the constraints.
So, Erin, how about in San Francisco? Same or different?
We're the same, Jordan. I was just looking over a list at, the testimonies that we've conducted, interviews, joint proffer sessions, some even with the criminal authorities. And we've done quite a few of them. And so I think we're proceeding in cases where we can as well. And I was even looking through the list of defense counsel, and, there are people that are represented by national law firms as well. Some situations where even, the lawyer can't be with their witness, but it's been, again, I've been kind of impressed by everyone's ability to move forward.
So, Erin, I heard on an earlier panel that instead of spending their time commuting, SEC attorneys are now reviewing documents. I mean, how does the union feel about that?
You'd have to ask the union. No, honestly, I really feel, we said this during our planning call, I think the agency has been really responsive to folks' need to work, different hours than they normally would or things like that. And I feel like it's really just been liberating. I think folks are just, finding ways to fit in work when it works for them. And so it really has been a real benefit.
Right. So Randall, we just heard from Michele that, she'll be sympathetic to claims. So do you find that, your clients have a few other things on their minds these days rather than producing documents and showing up for testimony? Are you able to get more time and get other accommodations?
So, Jordan, on the Monday after, I think basically all of California had gone into lockdown. So the stay-in-place orders had been issued for, I think, the entire Bay Area, for New York, for Southern California. That Monday, I get an email from an SEC staff person saying, writing to follow up on the status of your client's document production. No, hope you are safe and well. None of that. I mean,
where's the empathy?
Why bother with those?
Where's the empathy?
Why bother with those pleasantries? It was literally that Monday. The whole world sort of feels like it's falling apart. Everyone is living in uncertainty and if not fear. And I get this email saying, "Where's your document production?" So it just goes to show that no matter how great the regional director is, there's only so much policing of good judgment that one can do. But I mean, that's obviously an isolated, it's a true example, but it's an isolated example. And I will say my sense, in fairness, sort of anecdotally from my own experience and talking to my colleagues, is that the staff has been reasonable. The staff has been accommodating. The staff has understood the challenges that document production, that witness preparation, all of this has presented. And so I think, that's been obviously, I think appropriate, but it's been good to see. What I think that the challenge is going to be going forward is that, it's only been, in the scheme of things, it's only been, 8 weeks or so that we've been facing this. And it has been, I think, understandably easier for defense and for the staff to put things off, to defer some things for some period of time. I think where push is going to come to shove is as this circumstance continues, and if we're still under a lot of these kinds of restrictions in the summer and going into the fall, how much more patient and understanding is the staff going to be? And in particular, what I'm concerned about are taking testimony and taking depositions, where from my perspective, being in the same room with my client is really critical. And, I have clients who are, fairly elderly. They're not even going to want to sit in the same room as me for some period of time.
Randall,
and so I think it remains to be seen.
Let me stop you there for a second. In terms of testimony and Zoom testimony, I mean, that is in some ways where the rubber meets the road, because you can review documents anywhere, but how do you have your client in one place and you're in another place and you're not, and there's important testimony? Is that something you're trying to avoid, or have you gone through that?
No, that's exactly what I was referring to. I mean, I would absolutely try at all costs to avoid that. There's just you can prep your client, you can do all of that, you can try to do it by video, but there's just no substitute for being in person with him or her, and both to prepare for the testimony or the deposition, and also to be there during it. So I have not had the staff insist on proceeding yet, but as I say, I think the challenge is going to be as this goes on, and we start to get into the summer and the fall. We'll see how it turns out.
Well, maybe you each get a mask and you sit 6 feet apart at the conference room table, and we'll see. We'll see how it goes. Okay, so Jina.
Yeah, as I said,
go ahead, Ryan.
I think for there are clients who are not going to feel comfortable with that. So, if they're not in good health, for example, I just don't. I think to sort of insist that that kind of deposition or testimony go forward, I think is problematic.
Okay, Jina. So moving a little bit away from COVID, I was looking over the Enforcement Division's annual report for last year. They listed 6 cases as notable, and 5 of them were accounting cases. Cookie jar reserves, that kind of thing, and actions against auditors, against PwC, against KPMG. And I thought, this is all taken care of, Sarbanes-Oxley and all that. So is there a resurgence here, or what are you seeing?
I do see a bit of I don't know if you'd call it a resurgence. I think the division, at least pre-COVID, was dedicating resources to accounting fraud, issuer disclosure cases. The SEC has always been, I think, devoted to these cases. The staff is motivated to do these cases. They're motivated to bring them. They have the skills to bring them. They're on point with the mission of the agency. They have the resources to bring them, and they generally leverage defense counsel in investigating and bringing them. So I think you can look at the cases that were cited in the enforcement director's report, which I think gives you some information, but also just the cases that have been announced in the last 6 months that don't even make the director's report. They show that the division is devoted to these cases and motivated to bring them. I think there are some high-level observations that you can make about these cases, and we can call them accounting fraud, we can call them disclosure fraud. But for most of them, I think one thing that's kind of interesting for those of us who have in this space is that a lot of them, the drivers are not gap violations. These aren't restatement cases. They're not instances where the numbers were wrong, not clear misstatement cases with quantitative materiality. And that's consistent with some of the trends that I saw even when I was at the commission. What you're seeing, I think, are cases alleging false or misleading qualitative disclosure. So, if you look at the cases that were listed, which I think are some of the more high-profile cases that the division wants to highlight, you look in the case of Facebook, you're talking about misleading statements regarding the company's privacy policies and whether user data had been sold, and that's a case that we've seen before. And I hope for the being in the defense counsel's chair, I hope that it's a case we won't see that much again. But that idea of hypothetical disclosure where the company says it may have a problem, but it actually does have a problem, those are very compelling cases for the commission to bring, for the division to bring. I think people understand that. They see they're kind of, they can understand that you're not being truthful about your disclosure.
So Jina, you mentioned leveraging defense counsel. Sounds very painful. What were you getting at by saying that?
Well, I think that a lot of times when it comes to these disclosure cases, they involve internal investigations and they involve law firms getting involved, being tasked by either the audit committee, a special committee, the board, to do an investigation and to see what happened.
Okay.
But I also, go ahead.
No, go ahead, Jim.
No, I just think another trend I think that you're seeing in this space is the division is willing to bring kind of negligence-based cases in this space. So a lot of those cases were negligence-based. They're not Sientra-based cases. They're not 10B cases. Some of them don't involve individuals, which I know is a driver of a lot of these cases, but they will bring them without them. I think they also involve civil penalties, which I think for a while there, at the beginning of this chairman's tenure, there was a question of whether the SEC would be issuing issuer penalties, and especially in the case of negligence. So you see that as well. I think there are, like when you look back on it, I think that this ground was laid in 2013. Like you had Andrew Serezny kind of coming out saying after the financial crisis, from 2008 to 2012, there was this diminishing number of accounting fraud cases. And I think we were coming right off the financial crisis. And there was a question of, did Sarbanes-Oxley work? Does this mean the death of the financial fraud cases? And they put up a task force, I think it was called the Fraud Task Force. And so they devoted resources to it. And I think what you're seeing right now are cases that are coming out of there. And it's interesting because are they the WorldComs, the Tycos, the Enrons? I think you might argue no, but there have been several interesting, and even I would say in the last few months, a couple old school cases where you are talking about like side letters and 10B and the criminal authorities getting involved.
Okay, thank you. So let's switch back, Erin, to COVID and talk about the kinds of cases that involve COVID and what you're pursuing. And it could involve anything from saying you got N95 masks to, accounting or insider trading. What kind of resources are you putting towards ferreting out COVID cases?
So I think, and I know CP can talk a little bit over the lunch hour about this, but, when I look at our office and what our office is going to put resources into, I think we try to be responsive to all the constituents in our region, right? And so obviously there is a need to look into cases that involve COVID. So are we going to devote 100% of our resources to that? No, we're not, because there still are a lot of other cases that need to be brought. But of course, this is something we're going to address as well. So, obviously, the flat out scammers, the market manipulators, the pump and dumpers, we have some of those in our inventory. Those are going to be the easiest and the fastest cases to bring. I think that's what you'll see right out of the box. You've already seen, quite a number of trading suspensions. I think some of those will also turn into fraud cases. But we've also been paying attention to more sophisticated companies. So, not the people who move from faxes to, the fax blast cases to, the next big thing, who are now doing COVID scams, but more sophisticated companies in the Valley that have made claims about lines on PPE, vaccines, treatments, whether they have preferred contracts with certain cities or first responders, things like that. Those are going to be harder and they're going to take longer, but we have those as well. You mentioned insider trading. I think that's a huge focus. I think we're paying a lot of attention to the trading activity around big announcements by certain companies. I think that will always be something that we're really focused on. I think especially in the situation where you have so much market turmoil and so many people are suffering, if people are profiting ahead of those types of announcements, that's a huge issue for us. Matt Jakes talked a little bit this morning about something that we're also paying attention to, people that might be bearing write-offs, asset impairments, goodwill impairments, inventory write-downs. If those are things that should have been taken in prior periods but are now being buried as part of, the company's response to COVID, that's also something that we're taking a look at. And then I think finally, and I think it's sort of Valley specific, but, companies that are making claims about their ability to operate in light of the shelter in place orders, when they know they can't operate or they've been told they can't operate, we are going to be looking to see what those companies are saying. I think pre-COVID, you had all these IPOs come on board last year, some of them with mixed results, really. You saw this real shift away from, high growth is all that matters. You saw a shift, now the funders are starting to look for profitability and things like that. And so, you can't grow right now, and it's very hard to demonstrate profitability right now. So it's going to be interesting to see how these companies in the Valley adjust to the new normal. But those are some of the things that we kind of think about just conceptually at this time.
So Erin, you were just talking about the Valley. Michele, how about outside the Valley, going to Los Angeles? Similar kind of emphasis, or what are the specifics down there?
No, I would say, they're pretty much exactly the way Erin had listed them out. All those different areas are areas, of heightened concern and awareness. But, to your other point, there's been numerous instances over however long anyone's worked at the commission where, emerging market events then cause, a reevaluation or consideration of where we're deploying resources. And it's never, all or nothing. So it's not like everyone has dropped their existing investigations and turning to COVID matters. But, we're mindful, obviously, and want to be receptive and address, the wrongdoing, which just, again, my own view, kind of exploiting and capitalizing on, a horrific worldwide tragedy is pretty odious. So people are eager to address people who are trying to profit from the misery that so many are suffering from.
Okay, we'll keep that in mind. So Randall, switching gears a little bit, but just a little. On April 8th, Jay Clayton and the head of Corp Fin they issued a very interesting statement, which I really recommend everybody read. It's short and it struck me as quite different from a usual SEC statement. And they asked companies to provide more forward-looking information in light of COVID-19, that it will help the United States recover if companies provide that kind of information. I mean, I remember the days when the SEC said don't provide forward-looking information. And that was a long time ago, but still. So Randall, you're advising your clients, well, gee, Jay Clayton said we should provide more forward-looking information. I guess that's what we should do. We should be patriotic and do that. Is that what you're advising? And what's your reaction to that statement?
I guess I would say a few things in response to that statement. First, I don't know that the statement itself, given the extraordinary circumstances that we're all facing, was particularly unusual. I mean, these are unusual times. And so it struck me that the statement was an appropriate set of guidance and sort of ways of thinking, given the extraordinary nature of the times. Secondly, I think companies were going to be struggling with disclosure issues surrounding the impact of COVID-19 anyway. I mean, it's not as if companies would have thought, well, gee, this is not really something we need to think about in our risk factors or our MD&A. So I think it was helpful in providing, sort of fleshing out and giving a little further guidance as to what companies, I think, were struggling with in any event. It's also the case that, companies have always had to do forward-looking disclosure in the context of MD&A. MD&A requires disclosure and discussion of known trends and uncertainties, and certainly COVID-19 would fall into that category. So I don't know that it was that dramatically different in kind, given general principles of disclosure. I think where some of the trickier sort of questions or circumstances are going to arise are, number one, drawing the distinction between sort of hypothetical risk disclosures and a disclosure of something that has already happened. I mean, that's sort of an issue that the SEC and including enforcement has sort of focused on in the past, where something is characterized as a risk disclosure, a hypothetical forward-looking risk disclosure, when in fact that circumstance has already occurred. I think the global pandemic sort of presents a particular challenge in trying to report on and disclose both known facts within a context of just extraordinary uncertainty. And so I think that is a particular issue that companies are going to have to pay attention to. And then, of course, the overlay for all of this is that anything any company says is always going to be judged with the benefit of hindsight and sort of 2020 vision. So that's just sort of the reality of
Randall,
how the SEC operates.
I guess the answer to my question is no different from anything in the past.
Well, I think the principles are no different. I think the challenges are, extraordinary,
Sure.
Given, as I say, both extraordinary challenges that companies are currently experiencing, but combined with just a tremendous amount of uncertainty as to what the future holds in any number of different respects with respect to governing a company's business.
Okay.
One thing.
Oh, go ahead, Jina.
Just really fast on that. I just know, like in that statement, I think what's kind of interesting is it's very, Jay Clayton and Bill Hinman are disclosure lawyers or capital markets lawyers. And so one thing that I thought was very, that can be very helpful is they explicitly said that good faith attempts won't be second guessed. So we should all remember that.
Yes. And we should also remember they said
they will absolutely be second guessed.
Well,
you just have to hope that the good faith part of it is an appropriate defense.
Well, the other thing I found interesting is the statement said that, what happened in the past, given what's going on now, is nowhere near as important as it typically is, because there's a real pivot point with COVID-19. So, there's maybe a question about looking into whether a company's accounting from 2 years ago got the quarters right. You could quote Jay Clayton on that, maybe. I don't know. What do you think, Erin?
I think I should really say that the views I expressed today are my own and not anyone else's when we're discussing Chairman Clayton's statement.
Okay.
But But I really agree with, everything that Randall and Jina said. It's, it's extraordinary times, and those call for different types of measures. And I've also noted the safe harbor, the encouragement to rely on the safe harbors. I don't view it as an enforcement statement.
Okay. All right, Michele, let's go back in time, way back. Let's see if we can remember back to November of 2019. And there was a statement, again, this is in the annual report, that one of the goals of the Division of Enforcement was to accelerate the pace of investigations. It would take 37 months to do financial fraud and 24 months to do other kinds. And we've got to accelerate that. I'm guessing that that's no longer a priority, given what we're doing here and so forth, but maybe that's not right. So where is that?
Yeah, Jordan, I don't know that that's right. We are still mindful of, trying to move the cases, and a case has its biggest impact when it's brought in as close in time as to the conduct as possible. So I think that's just something, going back, and I'm sure Randall remembers, and probably Jina too, under Harvey Pitt's tenure, the concept of, quote, real-time enforcement was front of mind. And I think, as you all know, like many of our cases are challenging, they're complicated, there's numerous parties and complex issues, and things just do take a certain amount of time. Notwithstanding that, there are ways that, any one team, can move a little more quickly, perhaps, as the case warrants. So I think it was just sort of putting that, in the whole division's front of mind to just keep mindful to, make the cases, progress as rapidly as possible given the circumstances. So there's not like there's any new magic bullet or some new, tool in the kit, but just, where possible to, get documents produced, on a rolling basis, which occurs to prioritize both, with testimony schedules, where a company wants to cooperate, to invoke the leverage word, to, take advantage of, investigative work that the company has done, where we don't need to retrace steps. And obviously when we coordinate with other law enforcement and regulators, there's ways to leverage off the information and evidence that, other regulators have gotten. So, there is always a sense of urgency, and I don't think that has changed. There's obviously logistical and pragmatic challenges now that everyone's facing, but I don't think in any way that's created a different mindset or imperative to people to try to, bring the cases to a close as soon as they can.
Well, Michele, you mentioned cooperation. So, Erin, another thing I read is that the division is endeavoring to find additional ways to message what companies and individuals have done to merit cooperation credit. So a little murky, find additional ways to message what they can do to get cooperation credit. Can you shed a little light on ways that your office has done that or will do that?
Yeah, I can. It's funny. I like this question because it's the question that we get every year. So it seems normal, pre-COVID question. And I think when we talk about cooperation, like what I always say is the benefits are highly recognizable and tangible for individuals, especially. And I think there's a lot of focus on, how do companies actually get cooperation credit? But, and it doesn't seem like we talk about individuals as much. And I think, the benefits that individuals can get rather than being thrown in groups with pool counsel are there. And I think you'll see in a lot of orders, people get halftime penalties or people get less charges. Sometimes they avoid timeout. Sometimes they avoid charges altogether. Now, sometimes that's hard to talk about, right? Because if you are an individual who we've decided not to bring charges against because they cooperated, maybe the right message is not to publicize that. Other times, the right message is to put it in the order or put it in a press release to talk about. I think some of the earlier panels today talked about our Jumio case that we brought, charged both the CEO and the CFO. The CFO did cooperate. His cooperation was mentioned in the order, and if you read through the order, his remedies are much less than the CEO's. That being said,
Can I just interrupt you for a second? Because you said something about not getting thrown in with pool counsel.
I think we see a lot of, I just think we see a lot of individuals at a company that are represented all by the same counsel. And from our perspective, and we do say this too, these people have, in some cases, widely divergent interests, but they're being represented by the same lawyer. And I can't see that being the right result for a lot of those individuals in certain cases. And so that to me is the part of the cooperation program that I don't think is utilized enough.
So do you think that jeopardizes obtaining cooperation credit to use pool counsel in those instances?
No, I'm not from a company. I'm just saying that individuals can benefit by cooperating. No, but I'm not saying that companies don't get credit because all those witnesses are being represented.
But those individuals may not be able to get cooperation credit in those situations, is what you're saying.
Or they may not even know that that's available to them.
Got it. Okay.
So, and then, the other thing that I'd say, just on the company side, you did see a zero penalty case against PPG earlier. But, I do think companies, like zero penalty is going to be rare, but you do see a lot of penalties that are not as high as they could be, a substantially shorter investigation, and then also maybe not some of the remedies that some companies might find extremely burdensome, like a monitor or something like that. And so I do think you do see there are benefits, even if the company is still charged and the company is still assessed a penalty.
Jordan, can I interject?
Yes, you may, Randall.
So it may well be that there are cases where where and the company knows that the result is better because of its cooperation than it otherwise would have been. What isn't clear, I think, from what's publicly available is the messaging. And that's what I think the reference in the Division of Enforcement's report was that the division would undertake additional efforts to improve the messaging surrounding the benefits to be had from cooperation. And at least as I've looked at releases, it doesn't seem clear at all that practice has changed. In fact, if you look at the two examples of cooperation, PPG, which you mentioned, and then I think ComScore is the other one that are actually called out in the Division of Enforcement's report, the orders sort of sound like any other order for a cooperating company. They acknowledge the company's cooperation, they acknowledge the company's self-reporting and remediation, but there isn't really anything more to it than that. And in fact, the press release for ComScore doesn't even mention the company's cooperation. You actually have to go and look at the order to see the acknowledgement of the cooperation. So I think it just goes to that sort of challenge that, we talk about every year, as you note, which is how do you actually know what the benefits of cooperation are going to be? And here, where you have the commission having said, we're going to make more of an effort to improve the so-called messaging, still not really clear how that's being done.
So I did get a question from the audience. The question was that the person said, it's my understanding the safe harbors do not apply to oral statements and analyst calls. If that's true, I've written a lot of briefs that violate Rule 11. So I think it does apply. So whoever asked that question, don't have to worry. Just read a little further in the PSLRA and you'll be fine. So let's, Jina, here's a question about speeding up things, possibly. I understand from watching Brian Williams that we're coming up to an election in 170 some odd days. Is that affecting strategy? I mean, are you thinking what it would be like if Elizabeth Warren is in the cabinet versus Jared Kushner? I mean, is that something that's occurred to you and how you strategize?
I would think that everyone who advocates in front of the commission, and that includes the staff, has to recognize that opportunities come up every few years. We don't operate in a vacuum, and this is an election year. And there may be more opportunities. There may be less opportunities. I don't want to make too big a deal out of it. I don't think that happens in every case. I don't think you can use that kind of in every day-to-day decision making. But I do think that oftentimes, and as we get closer to November, I think that issuers who are facing corporate penalties or an industry that is that has different scrutiny on it, depending on who is the chairman and who are the different commissioners. I think that those are real opportunities that that defense counsel and the staff, frankly, will think about as they are moving their cases through.
All right. So, Erin, I don't have much of a commute anymore. It's gone from 55 minutes a day each way to about 10 seconds, and I really can't stand it. But I have been searching for ways to fill my time. And I've been looking for, podcasts, things like that, and listen to the Daily from time to time. And I came upon a podcast called Secrets to Investing, a subject I'm quite interested in, especially the secrets part. And I noticed that the first three letters, SEC, were all caps. And then I noticed this is produced by the San Francisco office of the SEC. So I didn't realize you guys were getting into the podcast business. Can you describe for us what that involves and when you're going to appear in one of these podcasts?
Well, I don't know how many people in the audience know that our office, as well as the Los Angeles office, have been, I'd say over the last 2.5 years, been really engaged in a teacher investment outreach initiative. It's really about outreach and education. We're also, focused on kind of bringing enforcement investigations and examinations in the space based on what we've heard about some of the problematic practices that are happening with teachers. But it's primarily an education initiative that is kind of voluntarily undertaken by staff in our office who are really committed to this issue. And one of the ideas that the staff came up with is, kind of meeting teachers where they are. They don't have a lot of time. They want, short bursts of information that they can easily digest. And so they came up with the idea of recording some podcasts. And so we had three, really just talking about how teachers' retirement programs work. When Chairman Clayton was out in our office a couple months ago, we made the pitch to him that he should appear in one. And so last week, in connection with, recognition of teachers, last week, we launched the interview with Chairman Clayton as well. So I don't know, Jordan, if you'll get much out of them. They are aimed at teachers' retirement options, but they've been really rewarding for the staff.
And I can tune in even though I'm not a teacher, right?
You can, yes.
And Michele, are you planning a rival Southern California podcast?
No comment.
Okay. All right. Okay. I think we have time for one last question. And traditionally, we make a prediction, but since nobody was able to predict anything correctly for what we're all going through now, we're going to switch that up a little bit. And we're going to end this the way many conversations have ended these days, which is I'm going to go around the panel, and we're each going to come up with one recommendation for a show you can watch in your leisure, but it cannot be Tiger King. It can be anything but Tiger King, not because I dislike Tiger King, but because everybody's already seen Tiger King. So we're going to start with Jina. Jina, what is your recommendation to the group?
Okay, I'm always dated when it comes to these things, and maybe this will show my Anglophile tendencies, but I used to recommend this to Erin when I was back at the commission, but I still watch Great British Baking Show, which is wonderful, and I just started watching The Crown. And I did also want to plug one book that I ordered off Amazon. It is a book by Mark Fagel, who usually is on this panel. I think it is his memoir, and I just ordered it off Amazon, and it has excellent reviews. So you don't have to wait for my review, but that's another thing that one can do in these times of shelter in place.
Who's going to star as Mark Fagel in the movie version? I'll leave that for another panel to answer. All right. Randall, what is your recommendation for one show? So it's not a show and a series and a book. One show.
My one show recommendation is Schitt's Creek. It's about a wealthy family that loses everything and has to move and live in a motel in a town they bought on a lark. It's hilarious. It's poignant. It sort of talks about themes of family and getting back to basics, which is particularly fitting in this time. And for those of you who watch the show, there's a daughter on the show who bears a disturbing resemblance to our 18-year-old daughter. Although anytime I point that out, it makes her crazy and she threatens to leave the room. But I highly recommend the show.
Excellent. I've heard good things about it. Have not watched it yet, though. Erin, what is your recommendation?
So mine is Ozark. It's about a family that, essentially is money laundering, and they completely vex the FBI agents that are trying to catch them. It's great characters, and I think we all have an inner Ruth. And so once you watch the show, you will understand what that means, and you will be thankful for the recommendation.
Very good. And Michele, your recommendation.
Okay, so in keeping of the family drama theme, I highly recommend this Israeli series called Shtisel. The characters are really complex and nuanced, and I was completely addicted. And then for inspiration and heroes in a time when we could all use them, I have to put in my plug for Hulu's Hillary documentary. It is outstanding.
Okay, well, you took 2, Jina took 3, so I can use the moderator's privilege and mention 2. If you're looking for a great dramatic series, watch The Plot Against America. It's really terrific, based on the Philip Roth book. And if you want dark comedy that occasionally gets a little too sappy, Ricky Gervais in Afterlife. I think we've come to the end of our time because I see Bruce. Bruce?
I leave you all alone for 1 minute. I come back and we're doing TV. Very solid recommendations. I've seen a lot of those. All right. Thank you, Jordan. And as always, the director's panel is an absolute highlight. Our next panel on cybersecurity will begin at 2:10 p.m. Thanks again to the panel, and we'll see you all in a few minutes.